Yes, Mr. Gammy.
I was postulating a circumstance before the short adjournment where £100 million have been on short-term loan to Lehman's in the period before it went into administration. And I said there were 5 points. Just to summarise very briefly the 4 that I'd already referred to. The first was that effectively your contractual entitlement under the short-term loan that I was postulating is replaced by the proof of your debt, which of course is by reference to the circumstances at the point in time at which Lehman's went into administration. So we say A rather than B is the relevant point in my learned friend's timetable for where the source can be found. The second was that you know that if interest is going to be paid under the statutory scheme, by reference to which you're hoping to get your money back, that is going to be calculated at a specified yearly rate. It's not a short-term loan in the sense of Gosling and Sharp. My third point was that neither is it a matter of forbearance, because you cannot demand repayment of the money. You're effectively locked into the administration and the time that takes. And my fourth point was that there is no real distinction between interest which is paid in respect of either a trustee's breach, tortious action, claim for damages or the like, where the interest is paid at the discretion of the court and by reference to its decision, as we saw in the extract from Chevron. Here, if a surplus emerges, you know that you will get interest according to the statutory scheme. So they were my 4 initial points. My fifth is that I say it's yearly interest because it meets the test that was laid down 165 years ago by the Vice-Chancellor in Bebb and Bunny. And it's worth, I think, just turning that case up again. It is in the first authorities bundle at tab 26, page 473 in the bundle. Subject to the contingency that we've noted in relation to the requirement for a surplus to emerge, the interest may have to be paid de anno in annum, as indeed it was in this case. It does not have to accrue de die in diem. We can see that from, or we can certainly work that out from what the Vice-Chancellor is looking at in Bebb and Bunny. So we can see right at the beginning, it says at the top of the case report, a purchaser liable to pay interest on his purchase money may deduct income tax from such interest. And one can envisage, on the basis that what was being argued here was whether or not interest was yearly interest and therefore payable subject to deduction of tax, that those arguing against that proposition would have pointed out that the interest in question accrued de die in diem. And no doubt the argument was put that interest that so accrues in those circumstances is not annual interest. And that is why the Vice-Chancellor compares what he's looking at, which is interest accruing de die in diem on unpaid purchase monies, compares it with mortgage interest, because as he notes, once a mortgage conventionally has reached a 6-month point, it may technically be repayable, but thereafter the interest accrues de die in diem, and that is nevertheless recognised to be yearly interest. So the fact that something accrues de die in diem doesn't mean that it is not annual interest. In other words, the Vice-Chancellor is not saying that interest must accrue de die in diem to be annual interest. He's in fact saying the opposite. And of course, statutory interest may not accrue de die in diem if one takes what Justice David Richards' description in Waterfall 2A, but it can be expected to be calculated, and indeed in this case was calculated de anno in annum. And of course the point about why interest on unpaid purchase money, even though it accrues de die in diem, can nevertheless be yearly interest, is because it is capable of exceeding a year. That is the fundamental distinction between Beban Bunny and a case like Gosling's, because in Gosling's it was quite clear that the interest was not capable of exceeding a year because it was a loan for 3 months. So I say that the relevant principle is precisely the opposite, as what my learned friend says. He says that if it's of uncertain duration, then it must be of a short interest type. I say, no, the relevant or the more relevant principle is to ask whether or not, even though it's of uncertain duration, that it's capable of exceeding a year and therefore may be paid for more than a year. And you can see in relation to cases such as Garston Overseers and Gateshead Corporation that although the interest may have been paid for more than a year, when you look at the nature of the arrangement, the short-term deposit in Garston Overseers or the unpaid but demanded debt in Gateshead Corporation, in neither case would you anticipate that that would exceed more than a year. That is plainly not the situation which we're facing here. The point is made, in fact, in the case of Craven's mortgage, Davies versus Craven, which is at tab 48 in volume 2, and in particular at page 798. Where Mr. Justice Warrington is looking at Beban Bunny, and we can see in the middle of page 798 he turns to say, now I turn to the case of Beban Bunny, which I think is directly in point, and then going down a little way, about 2/3 of the page, where he begins, in all essentials, that was exactly the same as the present case. It was a contract to pay a fixed sum at a certain date, and if that did not take place, to pay it with interest at 5% at an uncertain date. It matters not that that date was in Beban Bunny fixed by the completion of the contract, and in the present case, by a man's death. It was an uncertain event which might occur after a longer period than a year. That is the relevant principle that Beban Bunny
Sorry,
illustrates.
I'm not quite clear how you distinguish that from Gateshead, where clearly the payment might occur a year later.
So in Gateshead, the corporation makes an immediate demand for money from the frontager. And of course, it could immediately sue for that amount of money, but it chooses not to, and interest runs, and the debtor eventually pays or pays by instalments over a longer period. What is important in the case of particularly these early authorities, so this goes to my learned friends about it has to be an investment. or some degree of permanence, the person you're thinking about is the debtor, because it's the debtor who pays the interest, who has the obligation to withhold, and if it's yearly interest, to offset the tax that he withholds against the tax on his other income. So you need to think about this from the debtor's perspective. In Gateshead Corporation, it's merely the forbearance by the creditor that results in the interest accruing for more than a yearly period. So what the creditor chooses to do, in other words, he's entitled to sue immediately for his sum of money, but he chooses not to. His choice not to sue for the money immediately doesn't turn what is effectively short-term interest into yearly interest, unless, as Viscount Sumner says in his decision in Gateshead Corporation, there is actually some form of agreement between the creditor and the debtor that this can be paid over a longer period of time, in which case it can turn it into yearly interest because it can last for a longer period.
I wonder if you look at it from the debtor's position, if you're talking about, as you are at the moment, voluntary arrangements, you look at the nature of the arrangement from the position of the debtor and the creditor, both of them. Now, if one of them chooses to forbear, you say, well, that's not actually the arrangement between the two. That's something he is choosing to do. I wonder on what basis you can say you can only look at the debtor's position.
Well, I'm saying that you need to approach the question from the perspective of the debtor, because he's the one who has to pay the interest, and therefore for whom it's important, because by deducting tax at source, he effectively gets a deduction for his interest. It's the old form of getting a deduction for the interest that you pay. So in that sense, if I as a debtor owe you a sum of money which can be immediately payable, and which you can demand, indeed in Gateshead Corporation they had demanded, but you don't take any action to pursue that, that does not, I'm saying that does not of itself turn my payment into a payment of yearly interest as opposed to short interest, even though it may be that you choose not to pursue the debt for a longer period. It might be that within that longer period, you can imply an agreement between the creditor and debtor that it will be outstanding for longer.
Yes.
And indeed, it's noticeable in Gateshead Corporation that what Viscount Sumner says is that the Gateshead Corporation and the frontager could have arrived at that decision, in which case it would have been yearly interest.
So that's really why I was saying what I was saying, because the initial arrangement was short-term. They could have agreed to make it long-term. They didn't. One person chose to forbear. That didn't alter the arrangement.
Indeed, and Viscount Sumner says right at the end of his decision that effectively, you could say the basis of his decision was that the frontager on whom the burden of proof lay to demonstrate that this had become yearly interest had not discharged his burden of proof. And those are the Viscount Sumner's sort of final words. In exactly the same way in Garston Overseers, if we could just look very briefly at that, which is at tab 34 in the First Authorities bundle, you can see the same point. So you need to turn to, if you go initially to page 566 of the bundle, which I think my learned friend he took you to 566 because of what Mr. Justice Rowlatt says right at the bottom of the page, where he says the broad result of these decisions in these cases is that the yearly interest means substantially interest irrespective of the precise time which collected, interest on sums which are outstanding by way of investment as opposed to short loans. Investment, of course, from the perspective of the of the debtor. In other words, you've got something in the debtor's business, he's going to be paying interest. He wants to deduct tax at source because that's the way he gets a deduction for the interest that he's paying. But if you go on to page 567, you can see why Mr. Justice Rowlatt concludes that the interest in this case was not yearly interest, but was effectively short interest. It's about in just a short way down on page 567. He says, whatever may be the position of the overseers in relation to the question whether they are a corporation or trustees for charitable purposes, I should have thought that they certainly have no power to acquire a capital fund by levying rates and then investing that fund at interest. That is not what they are to do when levying rates. They are to levy rates as far as they can for their current expenditure. However, they must necessarily keep a small balance in hand, and they will get interest upon it under the arrangements which the bank were willing to make. It is no doubt contemplated that the balance will continue for a long time. But what is the daily balance? It's not even a short loan. It's merely money at call, money payable on demand. That is the position in point of law, and it's a position which is recognised by the practice of the parties, because the appellants draw a cheque at any time for a large or small sum, and to that extent reduce the balance. So here, it's Garston overseers have deposited the money with the bank on an at-call basis.
Sort of interest-bearing current account.
And it's effectively an interest-bearing current account, indeed. So, then right at the end, Mr. Justice Rowlatt says, I'm therefore at a loss to see how, in the light of the authorities, I could have any doubt, but that this is not yearly interest. I do not think I need say anything more, but you can see that this is just an interest-bearing, as you say, my lord, current account. And it's effectively the creditor, in other words, Garston overseers, who are just choosing to leave the money there for whatever term that they need for a short-term short-term money at call, rather than the bank agreeing that it will borrow the money on a long-term basis, or at least on a basis which is capable of or liable to exceed a year. In that case, of course, there is the flavour as well of what we see in Gosling about what is a sort of ordinary business practice and what people recognise. But I say that all of that is very different from the situation that we have here, where, as I said before the short adjournment, somebody, even though he lent to Lehman's on a short-term, 6-monthly or other less than a year basis, finds themselves, as a result of the statutory scheme that comes into existence when it goes into administration, effectively locked in as a longer-term investor, certainly one who, if a surplus emerges, will be entitled to interest on the money that they've got locked out, calculated by reference to a year, and certainly by reference to a period which is capable of exceeding a year, and in this case definitely did so, as we can see from my learned friend's own diagram.
When do you say we should start the clock? On the cut-off date? When do you say we should start the clock for working out whether it's run for a year? I appreciate you'll no doubt say, well, it doesn't really matter.
Well, it does.
In principle, when should we start?
In principle, we say point A.
Yes, to be that's the point where the money begins to be withheld.
Yes.
Yes.
Indeed. And we can see it goes right through up to point C. So, my lord, those are essentially my reasons why I say, or why we say, that this is yearly interest. My learned friend made a number of points which I will deal with. I don't think it'll take me too long just to run through some of the points that my learned friend made, with which I would just take issue to a greater or less extent. He said, in relation to the various principles that apply, that there must be a source, and that the revenue agreed with that proposition. I would just say, and I think this is clear from our case, interest is an unusual thing because it is charged as a species of income in itself. So in a sense, in many circumstances, all you have to ask yourself is, how is the character of this payment interest? You don't have to concern yourself significantly with any sort of subsidiary question about whether or not there is what the source is. As we say, the character of interest is such that the most obvious source is the money in respect of which, or the obligation to pay the money that gives rise to the interest that ultimately is paid. My learned friend made a brief point in passing right at the end that source is important and must exist in and that we'd said in our case must exist in the period for which it is to be charged. He said that by reference to our footnote to National Provident Institution and Brown. That, of course, that case was back in about 1922. And of course,
this is page 64. I was going to ask you that, paragraph 17 of your case, MS 64.
Yes, my lord.
What was going to say about that?
Well, my lord,
And
I'd
the
say
fact it was a 1922 case, doesn't it?
it was obviously very important in years when you had things like the preceding year basis of assessment
Yes.
and different rules of assessment for opening and closing years. So, for example, it became very important to know if you made, and there was indeed a revenue practice, if you made a very large, suppose you had a deposit account and you added a very large sum to the deposit account in one particular year, you might need to know whether or not that very large deposit gave rise to a new source of income, a new source of interest, or was a continuation of the previous source, because different rules of assessment would apply according to opening and closing years, and the whole variety of other points that arose in relation to source. That is not relevant in the present case, we say, because the sole question is whether or not, when the interest is paid, it's yearly interest of money, and then Section 874 imposes an obligation to withhold at source by the administrators. So it's not an issue that is of...
You say, in fact, you're saying at paragraph 17, the obvious source is the sum of money by reference to which the payment is to be ascertained. But right?
Yes.
They're allowing Mr. Justice McGarry.
Indeed, my lord. I mean, it would be very strange if that did not feature in the question of source. It's surprising that, given the longevity of these rules, that there are relatively few cases in relation, sort of directly relevant, saying what is the source in this sort of context. It rose particularly as to whether or not interest was a UK source or foreign source interest, because that made the difference between whether or not there was an obligation to withhold at source or not. And that is the authority to which we refer in our case, the National Bank of Greece case, which is it's tab 46 in volume 2. Which is at 769 of the bundle. And the question there, as we explained briefly in our case, was that the original obligors on the debt, a Greek issuer guaranteed by a Greek bank, so as far as Greece had been concerned, the interest was no longer payable, but as the obligation was covered by English law, or governed by English law, it was still enforceable in the UK courts. But by the time that it came to be enforced, the guarantor the identity of the guarantor had changed. You can see just in the head note, it summarises it on page 769, where it says in 1949 the Greek government imposed a moratorium on all obligations under the bonds and continued it to the present date, so that for all practical purposes the liability of the principal debtors and the guarantors in Greece had been extinguished and the securities in Greece were no longer available. Nevertheless, the holders of the bonds came to the courts in the UK and in a series of decisions, at least 3 of which went to the House of Lords, established that they were entitled to be paid, and the question then arose in Westminster Bank and the National Bank of Greece as to whether in fact in paying interest, or the guarantor making the payment under its obligation, it was liable to withhold tax. And that turned upon whether or not the source of the payment was a UK source or a foreign source. And you can see at the bottom of page 778 Lord Hailsham deals with that point. He says, I've come to the conclusion that the source of the obligation in question was situated outside the United Kingdom. This obligation was undertaken by a principal debtor, which was a foreign corporation. That obligation was guaranteed by another foreign corporation, which was, as conceded before us, had at no time any place within the United Kingdom. It was secured by lands and public revenues in Greece. Payment by the principal debtor of principal and interest to residents outside Greece was to be made in sterling, either at the offices of Hambros Bank or Erlingers Limited, or at the option of the holder at the National Bank of Greece in Athens, Greece, by cheque on London. Whichever method of payment was selected, it was pointed out before us that whatever use were made of the option discharge of the principal debtor's obligation would have involved in the ordinary course either a remittance from Greece to the paying agent specified in the bond, or the option of the holder a cheque issued within Greece, though drawn on London and presumably payable there out of funds remitted by the debtors from abroad. It was also pointed out that the bond contained no provision for payment by the guarantor of any particular place or in any particular country. The only circumstances relied on by the appellants as supporting their contention that the obligation was located inside the United Kingdom were as follows, and then he sets those out. And he says, just at D, speaking for myself, I do not see how an obligation originally situated in Greece for the purposes of British income tax could change its location either by reason of the fact that one guarantor has been substituted for another, or by the fact that the second guarantor so substituted subsequently acquired a London place of business, or by the fact that the government of Greece had, by retrospective legislation, altered by moratorium and substitution of a new guarantor for the purposes of Greek law, the obligations imposed upon the principal debtor and the guarantor. The appellants acquired no obligation different from that of the original guarantors, and that was the obligation imposed on the original guarantors by the term of the bond. In my view, the bond itself is a foreign document, and the obligations to pay principal and interest to which the bond gave rise were obligations whose source is found in this document. So despite all that had happened over the intervening period, including all the actions taken by the Greek government to try and prevent any payment under these bonds, the source remained effectively the original bonds, and the identity as a foreign source or a UK source was governed by reference to that rather than by reference, as had been argued, to the fact that the obligations under those bonds had been superseded by other obligations of the guarantors in the light of supervening events. So I say it's obviously not, and I say it's not directly in point in the sense that it's an absolute comparator with the current situation, but I think it illustrates how one doesn't look to the type of events that my learned friend would like you to look to in relation to all that happened since the start of the administration, one actually keeps one's eyes firmly on the commencement of the administration and what is proved there to identify what is the actual source of the payments that are being made. So that is what we say on source. The second point my learned friend made was that there has to be a term in respect of which the interest is payable, which he said will, rather than may, be payable for more than a year. I've already dealt with that, where I've said that's not the question. The question is whether or not it is capable of exceeding a year. That was Bebb and Bunny and Craven's mortgage. And then the point, his third point, I think, was that it has to produce an investment or something of permanence. I have dealt with that. I don't think I need add more to that.
Does it follow from that submission that all interest payable under this provision of the insolvency rules will be regardless how remarkably quickly the administration may go?
Well, I suppose
So it's looked at from the cut-off date.
Well, you've got, but it's got to be a distributing administration.
Oh yes, sure.
I'm liable to be trespassing on areas where I'm not fully qualified to trespass. But I suppose it may be that there are some administrations where the nature of the administration is such that it can be seen it's all going to be over and done and dusted in under a year. In which case you might make the case that actually you could see from the circumstances of the administration that it was never going to exceed a year. But I say that is just not our case that we have here.
Would that be consistent with the proposition that if it may be beyond the short term, then it's yearly? I think that was the point that Grace was getting at. I mean, if it doesn't have to, and it's sufficient that it may be more than short term, then it's yearly, then can one look back retrospectively and say, well, actually this hasn't taken a year, therefore it's not yearly?
Well, inevitably you're dealing with these things by way of hindsight, aren't you? Because that's the sort of nature of the statutory scheme, because we know from the rules that the debts have to be paid before you actually then generate a surplus in respect of which interest is calculated. So in a sense, there's always a degree of hindsight involved in this particular circumstances, which is perhaps, when I say slightly unusual, of course, is not generally speaking what you've been looking at in most of the authorities. I mean, most of the authorities have only dealt with things where you have had a definite short-term liability, or you've got the sort of Gateshead or Garston situation. So if in fact all the interest, the administration were done, the surplus were distributed, and it were all done and dusted in under a year, then it may well be you'd have a case in that sort of situation for saying, well, you could, whether you looked at it with hindsight or effectively looked forward with the benefit of hindsight, and you could conclude it wasn't.
Yes, I can see that. Just in a voluntary arrangement, you look at the nature of the arrangement itself. Here, you're in a slightly different territory.
Indeed, the statutory scheme puts you in a slightly different position, indeed.
Suppose if you had a distributing pre-pack with a surplus, you could just about get your head. It's all done and dusted, and you go into administration to implement it.
Yes. I mean,
I've ever come across one with a surplus.
My lord, your experience in this field is bound to be far superior to mine, so I couldn't comment on. Maybe I could ask Ms. Addy to comment on that when she speaks, if she wishes.
Yes, I've had some experience in administrations, and I can't envisage a circumstance where there would be a pre-pack if there was a circumstance.
Seem rather far-fetched, but there we are.
Yeah, so.
But I mean, maybe it's difficult to have a test, because at one point I noted you were saying it depends whether you would anticipate that it would last for more than a year. When you were talking about Garston, it's a rather different approach. I mean, one needs to have some sort of clear test, otherwise one doesn't know whether one deducts or one doesn't deduct, and as has been emphasised.
Well, after 170 or 80 years of uncertainty, I'm not sure how well, but of course, in the vast majority of cases, when I say people are clear, there are inevitably, as we've seen from the cases, there have been situations emerge where there has been a degree of uncertainty about it. In the case of, I say in relation to Garston and Gateshead Corporation, I say there isn't any significant uncertainty in relation to those, because it is just a case in Gateshead of somebody, of the creditor just allowing forbearance without there being any formal agreement as to the time that it should remain outstanding. And in Garston, it's a case of somebody depositing money on a basis at call, where again there is no real agreement, and business practice would tell you that that is not long-term or yearly interest. So I don't see a particular difficulty with those situations.
No, I can see if the test is, well, you look at the nature of the arrangement in a voluntary situation, or in a statutory situation, you would look at the nature of the beast created by the statute.
Yes.
And, there may be difficulties in some cases, but at least you know what you're trying to do. If you're simply trying to look at the subjective anticipation of either both parties or the debtor, then I think it gets a little unsatisfactory, really.
Well, I don't think you're looking.
I mean, you don't have to stick with that test.
I hope I haven't indicated that I'm sort of thinking it's purely subjective choice because I think both Garston and Gateshead Corporation and Garston Overseas tell you that it's not a matter of just one party's sort of subjective intention as to what happens. There has to be some sort of framework or agreement between the two in those situations, which is...
But I think if you're moving away from the idea that it's the debtor's point of view, which is a test, then I think I'd be happier.
Yes, I think it must be in these cases of statutory awards. If one thinks about the damages awards, for example, under the 1934 Act, riches, for example, the House of Lords had an argument in front of it that, of course, there's no question here of anything in reality accruing from time to time. It's simply an award made by a court, a lump sum. And the House of Lords' approach seems to have been to say, well, looking at what the purpose of the award is and how we calculate the award, it is in effect equivalent to the accrual of interest, DA and DM, recurrently over the period that's relevant. And if it were then trying to ask, are these damages to be regarded as analogous to a short-term loan or as analogous to an investment, the interest element, it couldn't possibly, I think, try to answer that question in terms of what intention could be attributed to the parties, because the whole exercise has got nothing to do with the parties' intention.
I absolutely agree with you, my lord, and if I've misled by sort of talking in terms of the debtor's perspective, my point was in particular in relation to cases like Gateshead and Garston,
yes,
where you are actually talking about,
yes, there is actually a transaction.
A transaction, yes,
yeah,
of some sort. But I certainly agree that you can't really think in quite those terms if you're talking about damages and interest accruing on damages or a sum that's found to be due under an order.
Yeah, and well, in this situation, you're really arguing that it's a similar sort of exercise, that although the court is making a single lump sum award, because the purpose of that award is to compensate for people being out of, not getting a return on debts that were owing to them, and because that's the purpose, and because you actually calculate the amount on the basis of an interest rate, it's therefore, you would say, I think, to be regarded as, for all intents and purposes, equivalent to yearly interest, or generate interest. And then if you're asking whether it's yearly or not, in a situation where it had been, well, the administration had been completed very quickly, like Lord Carnwath, I see the attraction of having a simple answer to that, which might rest on the fact that it's always possible that the administration will go on for more than a year.
Yes. Well, so I think the revenues perspective, certainly at earlier stages, has always been to say, well, in relation to a statutory scheme, that you can look back and see the period over which it's calculated, and exactly the same way as in the case of damages or any other type of claim or statutory arrangement. The question answers itself. I think my learned friend criticised that to some extent, and in a way, by answering my learned friend, I have approached it, or tried to approach the question more from their perspective, which sort of says, well, you have got to know at the beginning, or it has to be something looking forward that you've got to be able to answer. To which I say, well, whether you look forwards or backs, you get the same answer, because looking back, as the revenue has certainly said, is the way in which it can be approached. You can see the period over time for which the interest is accrued, and that answers the question that it's yearly interest. But even if you look forward, the simple answer is that most of these situations are going to be one where the interest is capable of being paid over more than a year. And I say that is the test. That's the Bebb and Bunny test. It's not just a case that there has to be some agreement that it's going to be outstanding for more than a year. The question is it capable of being outstanding for more than a year?
And there must be an equivalent question in relation to damages. But if, for example, a claim is settled very quickly, but nonetheless there's a court order made, or if simply the court processes a claim very quickly, it must be a well understood, I would imagine, because it's such a familiar situation.
Yes.
Presumably there is an established practice of how you deal with the taxation of interest in that situation.
I'm sure most of these, as you'll see from Bebb and Bunny, even back in 1854, the Inland Revenue was being consulted as to what the nature of their practice was in these things. And I think there is, I'm afraid the name of the case has escaped me, but I think there is a slightly earlier authority than Bebb and Bunny, which is not usually cited, because I think all that was said was, well, we've noted what the usual practice of the masters is in this area, and we're certainly not going to reach a decision which sort of completely overturns what they've all been doing, which was, of course, to deduct tax from payments that were being made out of court. My Lord, again, just a few points that my learned friend raised, which I should just mention. We say that the fact that the technicality that that Lehman's could have been put into liquidation, and that would have destroyed the basis upon which any interest might have been paid in this case, is neither here nor there. What one has to deal with is the payment that has actually been made, not if that occurrence had been the way matters turned out, there would be no payments and there would be no question to answer. But we say that that possibility is not relevant to the determination of the character of the interest as and when it is paid, in the absence of anybody having gone into liquidation. My learned friend made some points in relation to section 811 of the Act, which I think, as we say in our case, 811 was the limitation on liability for non-resident persons, so that where they receive interest which has not been subject to deduction, the United Kingdom does not claim any tax in respect of the interest that has been paid without deduction at source. My Lords, I think we deal with this in our case. We don't actually see that it has particular relevance to the answer in this case. As a purely technical point, the interest is charged a tax because what the UK tax system does is charge the item of income, in this case interest, which is UK source interest, to tax. So section 811 technically doesn't give an exception. It just effectively says that there's no tax to pay for the non-resident in those circumstances on that item of income, which is slightly different, I think, from the way my learned friend explained it, but is not, I think, of significance here. My Lord, I think you also drew attention to the insertion of subsection 5A to section 874. This was at tab 3 of the authorities bundle.
Yeah.
Again, we say this is of no significance in relation to the issue that you are asked to decide. As I think it was said earlier, the provision was introduced in the Finance Act 2013 to deal in particular with the very large number of payments that were being made, mainly to individuals. And it was to put, when I say to put beyond doubt, it was to ensure that interest, that tax was deducted at source, because otherwise the many thousands or hundreds of thousands of individuals who were receiving these payments would have had to have made a tax return in respect of them, when of course the vast majority of them were small taxpayers.
I wonder, does this provision answer the question I raised just a few minutes ago? Giving us a bright line rule for how interest payable in respect of compensation, whether it's for PPI or personal injuries or whatever, is to be dealt with.
Yes. But it was, when I say it was essentially, the reason was essentially an administrative reason to avoid the need for many hundreds of thousands of individuals who wouldn't normally make a tax return to have to make one, or of course, be at risk of penalties if they failed to make one.
This would be a regulatory payment rather than some award of interest under a judicial discretion.
It would have been a payment, I think, by...
Payment by banks under a regulatory scheme.
Yes, that's right.
What I'm really saying is if this is about, although we can't tell just from looking at it, if this is about PPI, it's not about compensation as a result of a court order.
No, it's about the PPI payments, indeed, my Lord. I think in his final remarks, my own friend made one or two points which, again, I think I can deal with very briefly. He said that the source was unique in this particular case and does away with the original debt. Well, as we explained in our case, we don't disagree that the original debt as the source disappears, but I've dealt with where we say the source comes from in relation to the proved debt. he also made the point that the source disappears at point C in his table, to which I have to say I don't see the particular significance of that, because interest paid after the debt's been repaid doesn't cease to be interest just because the principal has been repaid. He mentioned National Provident and Brown, which I've dealt with, and I think his final, very last point was the administrators have to proceed with all due speed, but I'm not sure that he necessarily developed that point specifically, so I don't think I have anything particular to say on that. Yes, my lords, just in terms of, again, of my learned friend's timetable, we can see that the administrators did not have permission to make a distribution to unsecured creditors until more than a year after the commencement of the administration, which we say is just a further factor which points, certainly if you're looking at it from the commencement, but even looking at it back, you can see that this was something that was not going to happen within a year, and therefore we say that is a further reason why, looking at this interest, you'd conclude that it was yearly interest. My lord, I think, unless I can help you further, those I have.
Thank you very much indeed. Miss Addy, do you follow? Mr. Goldberg.
If I've understood my learned friend's submission properly, it is that all interest is yearly if it may go on for more than a year. Or it may be that his submission is that all interest is yearly if it does go on for more than a year, and you look back and see whether it's gone on for more than a year. In either event, neither of those submissions puts a limit on the meaning of yearly interest. It does not define the quality which makes interest yearly. It just says, look at the time, and it's yearly if it's gone on for long enough. The authorities show that is not good enough. That is quite clear from Gateshead, and it's quite clear from Garston Overseers.
Can you point me to the best passage in either of those cases which supports what you've just said? Because, I mean, this goes back to the discussion we had right at the beginning of your submissions when we were looking at Ben and Bunny.
Can I do this actually by reference to Hay, which we didn't look at?
You now have
I've handed
tax
in,
cases.
yes, and it's page 646 of the tax cases copy. Now, the authorities referred to by Crown Counsel seem to me to establish these propositions, 5 in number. First, that interest payable in respect of a short loan is not yearly interest, with an exception. Second, that in order that interest payable may be held to be yearly interest in the sense of the Income Tax Acts, the loan in respect of which interest is paid must have a measure of permanence. Third, that the loan must be of the nature, and this is pretty well expressing the second proposition in another form, that the loan must be in the nature of an investment, Garston Overseers. Fourth, that the loan must not be one repayable on demand. And fifth, that the loan must have a track to future time. These propositions are perhaps one proposition expressed in different forms, but they are the result of the authorities. And he then goes on to say that those facts are not established in this case. If I can think that Gateshead in tab 35 is probably the next best place to go. One of the authorities, page I think the best place there is page 572 at the bottom to page 573. It said that the payment of interest in this case is a payment of yearly interest of money because it is not shown that there was any agreement setting a short term of less than a year to the loan which in fact the defendant was enjoying. The contention is that in all cases, except where such a period is fixed by agreement between the parties, there is a payment of yearly interest of money within the meaning of Section 40. And Lord Sumner clearly rejects that proposition in what follows. And he says it really doesn't matter how long the loan is outstanding. I'm unable to see how the words yearly interest can apply to this transaction. He says on page 574, there is no agreement for a short loan or a long loan. The debt is due and repayment is not enforced. Only in that sense is there a loan. Truly speaking, there's simply a forbearance to put in suit the remedy for a debt. And we can tell from, I think, page 569, if we read it through, it certainly seems clear that the loan has been outstanding for several years and the interest has not been paying, so that several years' interest is being paid at once. When this interest is paid, the interest in issue in this case. And Garston Overseers is to the same effect. Now, the authorities establish clearly that you have to have something in the nature of an investment. If we go through the characteristics in Hay, you first of all have to decide what it is you're looking at. Are you looking at the proved debts? Are the proved debts different from the original money that is advanced? Or are you looking at the statutory interest? It has been our case that you're looking at the statutory interest, that it does not accrue before it sort of fructifies on our diagram at point D. We rely on Mr. Justice David Richards for that in the waterfall case. We do not believe that there can be any difference between how the interest accrues for tax purposes and how it accrues for the purposes of the rule in Bowers and Morris, or for any other rule. It has to accrue in the same way, in the way laid down by the rules. According to that judgment, it does not accrue until the surplus is established. And if that is right, it cannot be accruing on the original loans or on the proved debts. It's coming out of the surplus. If we look at the surplus and apply what Lord Anderson says in Hay, those 5 characteristics, we are not going to find that any of them are satisfied in relation to a right which accrues at point D on our chart. It doesn't have permanence. It doesn't have investment-like qualities. And so on. It's just completely lacking in these features. If you're not going to look at the statutory interest, you can either look at the original claim or you can look at the proved debt. My learned friend has postulated an original claim of a modest £100 million, I think he used the term modest in context, advanced to Libby on terms that it was to be repayable on demand. There is no dispute that that produces short interest. If we are looking at the original debt, as the source, it must continue to produce short interest unless some magic happens because the loan becomes affected by the administration. My learned friend says that you have become a long-term investor. You are turned into a long-term investor by the act of administration. Well, you're not actually turned into a long-term investor. You are turned into a short-term investor who is stuck. That is a different thing from being a long-term investor. If we are looking back to the original debt, the bargain that was made was for short interest. The intention of the parties was short interest. The intention of the parties cannot be changed by an administration. The intention of the parties remains exactly what it was. It's affected by external influences. But if it's a matter of intention, you have to look to the original loan, and we know, the example my learned friend has given, that the interest is short. And in our submission, looking at the original loan, it's not changed into something long. In our submission, calling it the proved debt rather than the original claim cannot change the intention of the parties. It cannot affect what the parties intended the deal to be. Of course, because it's a proved debt and so on, it's affected by various statutory impacts. But that does not change the nature of the bargain made between the parties. Their intention remains what it originally was. They want their money back quickly. And the administrator is supposed to give it back quickly, if he can. The basic rule is you have a year to do it. You can get extensions, but try to do it in a year. And it really cannot be the case that the result is going to be different according to the length of the administration. As we know, in New York, Lehman's business was bought by Barclays. Barclays might have swept into the UK 2 months after the administration, bought the business out at a profit, and we would have had a distributing administration which might well have been over and done with within the year. Is that going to produce short interest when this one, because people were stuck, produces long interest? Or is it producing long interest even though it's short? I mean, the administration is short. These seem implausible answers. To say that it all depends on how long it's going to take is really not a satisfactory solution. To say that we look back with hindsight and discover, well, the Court of Appeal didn't look back with hindsight in Gateshead and say, oh, look, you're getting 5 years interest. Mr. Justice Rowlatt didn't look back in Garston. Nobody has ever looked back in cases where there was an agreement which started the relationship between the debtor and the creditor. They have always examined the quality of the obligation. Is it like an investment viewed from the point of view of the creditor and the debtor on both sides? Is that what they intended? That has always been the test, where the relationship starts off consensually. There is no case which says that the interest changes its character because of some statutory intervention. There is no reason in principle or logic why the interest should change its character because of some statutory intervention. Now, there are, of course, cases of damages. We see those as not inconsistent with the principle and not leading to the conclusion that in our case there is long interest, yearly interest. In all of those cases, there is a wrong done on day one day A on my chart, if you like, which runs continuously from day A to the resolution here on day D or E. That is not what happens in this case. If in the damages cases, the damages are imposed at day E or declared at day D, day D, and they relate for the whole of this 7-year period, during which the wrong has been continuing. If we are right, and the source here arises on day D, if we're right that it's the right to the statutory interest when it becomes clear in terms of business who is going to get what on day D, the obligation does not relate back to day A, it relates to the period from day D to E. That is unusual, but it is a necessary consequence of the peculiar nature of statutory interest, as described by Mr. Justice David Richards in Waterfall 2. Oh. Your Lordships have the passage.
Yes.
573.
If we're wrong about the source and the revenue are right, we still have, so that you go back, they say to day A. If you go back to day A and look at the original obligation, for the reasons I've already submitted, the interest is short. So the revenue are entirely dependent on the proved debt, bringing with it some totally different notional intention that turns the creditor from a short-term depositor into a long-term investor. And no, my lords, no, my lady, not turned into a long-term investor, turned into someone who is stuck. How does the original bargain get changed from an arrangement for short interest into something which is to produce long interest, because the administration comes along and the administration rules say you have to wait till your contract can be fulfilled? But essentially, it is the original deposit which is going to produce what comes back to you. To treat the proved debt as the source may be intelligible in some senses, but to treat it as changing the nature of the fundamental obligation has no coherence at all. My lords, there was some question as to whether the liability for interest is a right or a discretion. I believe that in equity, when equity awards interest, it's a matter of right. I think we can see that from the case of Barlow in the first volume of Authorities at tab 25. Page 468. Now, since that decision, it's the bottom paragraph on page 468. Since that decision, the matter has certainly been put on a clear footing by reason of the decision of the Court of Appeal in Barnato. Before coming to that case, it's perhaps desirable that I should refer to Vyse and Foster and the well-known passage in the judgment of Lord Justice James. If an executor commits a breach of trust, he and all those who are accomplices with him in that breach of trust are all and each of them bound to make good the trust funds and interest. If an executor or trustee makes profit by an improper dealing with assets or the trust fund, that profit he must give up to the trust. If that improper dealing consists in embarking or investing the trust monies in business, he must account for the profits made by him by such employment in such business, or at the option of the SETI trust. If it doesn't appear or can't be made to appear what profits are attributable, he must account for trade interest, that is to say, interest at 5%. Now that lays down the general principle which is applicable, and then he quotes to similar effect Lord Justice Roma Barnato. So in our submission, in the damages cases, there is a right running from day one which explains why you have 7-year interest. If Mr. Justice David Richards is right as to when the interest arises in this case, Mr. Justice David Richards as he then was, if he's right, we do not have the relationship back which exists in the damages cases, because the interest doesn't start to arise on day A, it only starts to arise on day D. If Mr. Justice David Richards is wrong, then where do we go? We haven't actually got any authority to steer us as to when the interest arises, and it looks as if we go back to day A and back to the original debt, which again leads us to short interest, because this is really a case of forbearance. It may be an imposed forbearance, but the original agreement remains an agreement for the short term, and it really cannot have been changed into something different by the imposition of the administration. Just one short point on the question of source. My learned friend has said, well, it doesn't matter whether the source is there or not because it's still interest. Well, it may be interest, but if it has ceased to be taxable because the source has gone, and his footnote 22 does appear to accept that, I think I've got the right footnote, it's very odd to withhold tax on account of a taxpayer's liability when he isn't going to have any liability because the source has gone. The very concept of yearly interest implies that it's taxable. And there is a huge problem for the revenue in maintaining that the source here is the proved debt, which disappears at C, but only produces income at E 4 years later. Unless I can help your lordships further.
Thank you very much indeed, Mr. Gelberg. Well, this is a very puzzling problem you've set us. It's interesting and important. We'll take time to consider it and let you know our judgment in the usual way.